Every consultant has intellectual property, or what people refer to as IP. Your IP comes into play when you're determining your focus and refining your focus. It is actually the one thing you want to be known for. Your point of view, your differentiator, is what makes you unique, is also your intellectual property. It explains how you solve your clients' problems. It drives your methodology and services. Your point of view is so important because it helps you stand out in a crowded field of other consultants. And it is your own intellectual property. Intellectual property is more than a patent or a book. And many people say, oh, I don't have a patent, I don't have a book, I have no intellectual property, but you do. And although I talk about the importance of intellectual property, I'm not an expert in it. By no means am I an expert. When somebody asks me, one of my clients, how do they go about protecting their intellectual property? I kind of punt. My responses are, here's a website to look at, or here are some books to consider checking out. But I also explain the best thing you can do is talk to an attorney. Talk to somebody who is an expert. So, in order to provide value to my clients, as well as people who listen to my YouTube channel, I reached out to somebody who is an expert, somebody who is that go-to person when it comes to IP. And her name is Erin Austin. I reached out and asked if she would be willing to have a conversation with me and have it recorded and have us talk back and forth about intellectual property. Let me introduce Erin. Erin graduated from Harvard Law, and she has over 25 years. Yeah, I'll get that out. Over 25 years of
I
copyright.
stumble over it too.
Thank you. Of copyright and contract experience. As I said, she is known as that IP go-to consultant, advisor for professionals, consultants, and coaches that work with corporate clients. What she does, and she's great at this, she helps entrepreneurs become their own best advocates. And she is focused on helping them transform from six-figure consultants into seven-figure powerhouses. And she does it through the creation, protection, and leveraging of the intellectual property assets. You'll get to know more about Erin as we go through this conversation. And of course, you can find out more about her on her website, Think Behind IP, and her LinkedIn profile. But something else I like about Erin, she has a great podcast titled Hourly to Exit and a YouTube channel. And don't hesitate to check out the YouTubes. She really has some great stuff. And what I'll do is I will put in the description area below links so you can easily find them. And as we talk, Erin's going to provide you some information or a link, and I'll put the link in the description area as well, to a survey. And I'm calling it a survey for lack of a better word, but it is to help you determine if you actually have intellectual property. So let me turn this over to Erin and ask her if I've missed anything.
You wrapped it up very nicely. You definitely got me there. And yeah, so I thank you very much for having me, Laura. It's a pleasure to be here. I love having these conversations. I love educating people about the intellectual property in their businesses. So I'm very excited about this.
Great. Well, let me start with a question I ask most people who come to me and they talk to me about becoming a consultant or expanding their consulting businesses. And my question, I'll change it slightly. With all the various areas of law that you could focus on, why did you decide to focus on intellectual property?
Yeah, I wish I could say it was intentional, but I've been practicing. I mean, the 25 years is, kind of the younger me. I've been practicing for longer than that, but I started working with very large corporations, and they were always in intellectual property focused industries. So in film, in publishing, in data, in research. And so, but, not that that's a big surprise, 90% of, the US's, GPA or GDP is intellectual property. But because of that, working with commercial transactions that involved intellectual property, it was natural for me to look at intellectual property as the point of reference when I started working with this new population. So it is more recent that I am working with the expertise based business in particular. I grew up inside corporate, working on huge transactions. And now I am translating that experience to helping expertise based businesses understand what the big corporations have known all along, because that's how they grow and profit, is we need to make sure we own and control our intellectual property. And so that became the natural progression from my corporate experience.
Since you've changed the who is your ideal client from that corporate person to that individual, that consultant, that coach who's working in the corporate world or working with corporate clients, what kind of problems do you find the consultants and coaches run into when it comes to IP?
Yeah, I mean, the number one is which very much shocked me, again, because I spent a career with everyone focused on IP, is that they don't realize that they have intellectual property in their businesses. So I like to say, if you are using your intellect, then you are creating intellectual property. That's literally what we're talking about. We're talking about copyrighted assets. And so we are, all day, every day, if you're working on a client deliverable, if you're creating a LinkedIn post, if you're, recording a podcast, like all these things that we do as experts all day, every day, writing an article for a journal, all these things are intellectual property. And so, something that a contractor is creating for you, writing copy for your website or helping you with social media posts, that's all intellectual property. It's flowing in and out of our businesses all the time. But most consultants aren't thinking about it that way. They're thinking about, okay, I'm providing services or I'm consuming services, but not that equals intellectual property, and that they need to be thinking about being intentional to make sure they're owning it and controlling it. So that's unfortunately sometimes too late that they realize that, but that is the key issue.
I can see that because I have watched many consultants, and I know you've written on this, and I've listened to one of your YouTube videos about this. People don't think that it's important, or they don't realize the importance of making sure there's clarity up front as to who owns that intellectual property. Do you run into many cases where people just haven't thought about that?
It is shocking to me, and I'm not naming any names, but there are some very big experts who are very proud of the fact that they never sign agreements. Like, that's like, you send out a quote and you get them to say yes, and then they go. And that's a point of pride for them. And I've been inside of networking groups of professional consultants, like, contracts. And at the end of the day, the default the fact that you're not using contracts does not mean that there's not this flow, this creation and flow of IP rights. Only thing that's happening is that you aren't owning and controlling any of them, and that the default under the U.S. laws is probably not what you think it is, and you're probably not going to be very happy when you find out what the default is when you aren't using contracts. So it dismays me when I hear that, because it doesn't need to be complicated. I still have corporate clients, and you will see those 50-page, 100-page master services agreements that come from clients. And I know they're terrifying, but it doesn't need to be that complicated. It can be very simple. I don't want us to be afraid of making sure we have our own forms of agreements in our businesses.
You've heard me talk about point of view, which I recommend every consultant have their own point of view. I say it's your, as you heard in the intro, it's your differentiator, it's your philosophy, but it also drives your methodology and your services, the actual services, because it all fits together. I know from experience that I had one client get very upset with me because in the standard contract that I had, the standard agreement, the legalese part of it, I had a section that actually said that this is my methodology and you cannot use it. And they're like, what do you mean I can't use it? I'm like, you can't use it. It's my methodology. And I've actually had consultants say to me, do you think that's important to do to spell it out? And of course, I punt again,
Yeah.
talk to your attorney. But in my opinion, it's important to make sure people are clear that if you have your own methodology, you own it.
Mhm.
Um, do you have any words of advice for people when it comes to something like that?
Yeah, I mean, we need to think about that both outgoing with our clients and incoming with any, maybe we use facilitators or contractors in our businesses. So if we have our own methodology that we have developed, then we want to make sure, I mean, if you have corporate clients and you're signing their agreements will say that they own all of the rights in the deliverable. Well, do you want to assign to your clients all the work that you've created? Absolutely not. So we need to be mindful of making sure we understand those agreements and that we are reserving all rights in our pre-existing methodology, know-how, workshops, whatever it is. We want to make sure that we retain rights in that because we're using it with all of our clients, right? And if we have, maybe you have a facilitator who works with you, and so they have access to all of your materials. You want to make sure that you continue to own it, that they can't, thank you for introducing me to your methodology. Now I'm going to go use it with my clients, or I'm going to go make a course with it, or whatever the case may be. So those are all things that we control with contracts. Again, doesn't need to be complicated, but it does need to be in writing.
Okay. And if somebody wanted to use your methodology, one option might be they could license it from you.
Yeah. A license, we think of licenses as this kind of, in the scheme, like the way we think about franchises, and you have, the trademark that goes with it and all the materials that go with it. But licenses actually happen all the time in our businesses. So for instance, if we go to the client agreement and I bring in training materials, I continue to own them. What that services agreement will say is that you, client, you have a license to use my training materials, but subject to these terms. Like you can only use it internally. You can't create derivatives from it. You can't post it on the internet. Or, you can use it for this cohort for X price. And if you want another cohort to go through it, they have to pay you again because you continue to own it. So licenses are anytime someone is using someone else's IP. That's all it is. So whether it's in the form of services or completely kind of DIY, where you're licensing someone the ability to just kind of take your training and implement it internally without you. And so I also want to kind of normalize licensing, and that it is part of what we're doing whenever we have IP and we want to put parameters around how people can use it. That is a license, and we want to put that in writing so everyone's clear on what the parameters are.
It gets back to having that standard document
Yes.
so that you agree.
Yes.
And as I've said to people in the past, I don't know how many times I've gone back to the standard agreement, the contract, whether it's a statement of work, it's a letter that's been signed to become that statement of work, and you have the standard. There's so many different ways, this, not, I don't have to tell you that, whatever it is. I've gone back to the original document, if for no other reason than to bring us back to where we started.
Yes.
Because as time goes on, memories change.
Yes.
And people don't always remember the same thing, or things kind of shift a little bit. And there's a reason to put it in writing.
I mean, isn't it wonderful to know everyone's on the same page and has the
Yeah.
same understanding? How is that bad? I can't, it's beyond me to someone go, oh no, I don't want to have a conversation about the terms. Like, but then that everyone is on the same page and being well served. Nobody wants to get anything over on, your client, and you should be partners. They want you to have a good deal. You want them to have a good deal because you want to have a long-term relationship. That means you want to make sure we all understand each other. If something does go sideways, that you have a process for resolving issues. This is just, just good stuff.
Common sense, right?
Yes, it is. It is.
What would you, what would you say to a consultant about attaining copyright protection? You know, some of these people that I work with, they're just starting out and they're overwhelmed. They're
Yeah.
overwhelmed with everything. You've set up a business, you know what it's like to set up a business.
Yes.
And here I come and say, I start saying, now you need to be aware if that's your intellectual property. What
Yeah.
would you tell them at a minimum they should do?
Yeah. I mean, what's important is that, well, let's just start with what copyright protection is and what it covers. So, copyright protection covers original expressions. So, by a human, and we're not going to talk about AI, but just let's just say that AI doesn't count. So, by a human, original expression that has a minimum amount of creativity. And so when you create something, we're all humans here. We create something that is our own. We haven't copied it from somewhere else. It doesn't have to be, something no one's ever thought about before, but it has to be not copied from somebody else. And it has some creativity. At the time we create it, at the time we put it in writing, type it into our computer, draw it on a piece of paper, take a photograph of it at the time that it is created and put, on some tangible form, it becomes protected by US copyright laws at that moment. Nothing else has to happen. However, in order to make sure that your rights are respected, there's a couple of basic things we can do. That we put the copyright notice, that C in a circle, and the year that it was created and who created it, if it's you or your business, whoever, however it's being owned. And that just puts the world on notice that you are claiming copyright ownership in that content. And if someone were to take it, and so your exclusive copyrights are the right to copy it, the right to distribute it, the right to perform it, the right to display it, the right to create derivatives from it, such as, turning a book into a film or making a translation to another language. And so those rights are exclusive to the copyright owner. So let's take an example of you create a training program, you create a workshop and you write all the materials for a workshop. At the time that you make your slides, you have copyright protection in that. You're going to put your notice on there and you have copyright protection. And if someone were to do any of those things that I listed, copied it, performed, displayed it, any of those things without your permission, that's a copyright infringement. For the next step of protection would be copyright registration. You have protection without registration, but registration gives you access to additional remedies if someone were to infringe your rights. And so if you are anything like me, or probably like Laura, who creates something every day, you're not going to register everything. It's all protected, but the things that you're going to register are what I call the money makers. The things that if someone were to infringe it, that you would go, I think I need a lawyer to, because they're stealing my workshop. They're stealing, they've duped my entire website, which I've heard of happening, things like that. And so that gives you access to the courts in order to get a remedy. But I would, so long as you are creating your own original materials, that's really the key. If you want to, get to the basics, making sure you're creating original stuff. A lot of consultants, they have assessments that they got from some sort of training program. Maybe they got it from their coach, they don't own that, but they need to be thinking about, okay, they have their point of view, a niche, a specialty. How are they then creating something original around the basic stuff that they're getting from their training program or getting from some other program that's making it their own? And that's really, everything is better, falls into place after they have that point of view and they're creating materials that reflect it.
So first, at a minimum, put that C, that circle, and put the standard copyright information at the bottom of the document at a minimum.
Yes.
Is what I hear you saying.
Yeah. Yeah.
And then go to the next step if you really have something that is the moneymaker.
Yes.
And I know people can do it themselves, but that is also something you help people with, isn't it?
Yes, it is something that I do help people with. And it is, I mean, unlike, I mean, we're not talking about trademarks today, but
No.
copyright registration, yeah, we're not gonna, but copyright registration is much less expensive than trademarks. And it is something that, requires it's all done online these days. And so just taking your time and going through the step by step, they have very good guides. They can do that if you're, comfortable with that. So either way.
Erin, you have something, a document, a survey. I call it a survey. You probably call it something else.
Assessment.
Assessment. Okay. That can help people figure out if they have intellectual property is
Yeah, so it is called can you copyright your expertise? And so basically it takes you step by step through the requirements of what is something that is eligible for copyright protection. For instance, we talked about it has to be created by a human. So if it's something that like for instance, driftwood might be very beautiful, but it's not eligible for copyright protection because it's created by nature. Is it something that is not considered creative enough? So, you might, the common example is, say, a calendar or something that's just a regular calendar. And maybe, you put some design on there or something like that. The design might be copyrightable, but not the calendar, not the dates and the things like that. And so it takes you through, there's a lot of, I'm simplifying it, but there's a lot of questions that take you through all the examples of things that would basically eliminate something from being able to be protected by copyright. And it will then give you an answer about whether or not generally your expertise is eligible for copyright protection. And if it's not, it will tell you why, no, if it's not, because it's, something in the public domain or whatever it may be. And so that is free on my website.
and I will put a link in the description area because I did go through it and it is a good assessment.
Oh, good.
I liked it. Otherwise, I wouldn't be mentioning it.
And is your expertise copyrightable?
Yes, it is.
Yeah, good.
Anyhow, before I wrap this up and ask my last question, is there anything else you would like to add?
I mean, the biggest issue is that I want people to not be afraid of intellectual property and or contracts. To me, they go hand in hand. We're talking about copyrights; they really go hand in hand, and that you don't need to become a lawyer or an expert, but I do want you to have a base level of comfort with them so that when you're talking to clients or you're talking to contractors, that you feel comfortable, because it really is a required skill in the 21st century doing business. It really is. And so, it is my job to make it as accessible and understandable as possible. But to give you the resources to make you feel comfortable, but I really don't want you to be afraid of it.
Yeah. And let me just echo what Erin said, because I say this so often to people that I work with. I'm not an attorney. I don't want to be an attorney, but I have made it a point over the years to be able to read a standard contract and understand what it means and understand enough of what is my responsibility as a consultant when it comes to contracts or an intellectual property and copyright, so that when I talk to somebody like Erin, I can have an intelligent conversation, because I think it makes the conversation a little easier and she gets the facts, because she's not going to remember everything and she's not going to know everything to ask because she's not you as a consultant.
Yeah.
So anyhow, my last question. What is that one piece of advice you would like to provide to any solo or independent consultant?
Start building. I mean, this is, I'm sure, what you teach as well. Like, start thinking about developing a niche or a specialty. And I know that seems like weird legal advice, but how it wraps in is that when people don't know how to stop billing for their services, it's almost always because they have an IP problem, that they don't have any. And so, I had a consultation with someone. He was billing a lot. He's billing a couple $1 million. But he couldn't get any further because he was completely undifferentiated. So if you needed implementation, if you needed strategy, if you needed, to build this or build that. And he grew just by adding more experts that he was paying hourly. And he did not have a point of view. He did not have a niche. He did not have a specialty. And so he couldn't break out. And I'm like, you actually don't need me. You need a coach, because until you figure that out, it'll be impossible for you to build any assets, because the assets come from working within your niche, working within your specialty, and you start to see patterns and you go, okay, I keep seeing this. I start to see the common problems. Oh, I start to see, the common needs. And then you can start to develop assets that address those specific patterns that you're identifying, because you keep working with that same group of people. And that's, when you think about it that way, creating the assets just comes naturally. It's not even a struggle. So that would be my
Oh, thank you, because that's so many times when I'm working with somebody who's started their own consulting business and they talk about, I don't have clients, or I'm overwhelmed and I'm working tons of hours. It comes down to the jack of all trades and the master of none, because it's not clear as to what is that one thing they really want to be known for. Like you want to be known as the go-to advisor, the go-to attorney when it comes to IP.
Yes, exactly.
And that's it. Well, Erin, thank you very much for your time. I appreciate it. And
Pleasure.
I believe my clients and the viewers on the YouTube channel will find this very helpful. And for everybody, I promise to put in the description area links to Erin's website, her podcast channel, her YouTube, and to the assessment. And take the assessment. It is very good.
Very good.
Take care.
Thank you.